the strip mall by Mainland High School that's on International Speedway. The citizenry has grown. You know, we were boasting 78,000, and I just heard in the neighborhood watch meeting from the city manager Monday night, we're at 81,000.
Wow.
So there's a draw for people to come. So I think Tanger Outlet, you know, Tomoka Farms, what they've done across the street. There's so much that we've done that has really kind of
Thanks.
Good morning.
Morning.
I'm sorry, this technology stuff is new for me. Am I on? Do I start? I'm sorry.
Good morning. It's 9:07, and I call to order the March 26, 2024 Rental Program Special Magistrate Proceeding. My name is Robert Riggio. I'm the Special Magistrate at this proceeding, and I'd like to get things underway. And we will go, there is a copy of the agenda over there, and we will try and stick with the order of the agenda. There appear to be more cases than there are people in here, and I suspect a number of them are appearing via Zoom, but we won't know until we actually get to those individual matters. So, I would like to move down the agenda. Are there any announcements?
Yes, sir. Page 4, case number 6, RTL 01-24-12 at 924 Vine Street is in compliance March 26, 2024.
Page 4?
Page 4, case number 3.
Oh, case number 3. RTL 01-24-12?
Yes, sir. 924 Vine Street
Okay.
is in compliance today, March 26, 2024.
Okay. Anything further?
No, sir.
Okay. I have approved the February 27, 2024 meeting minutes, and I have provided them to the board clerk. Now, the next item is, okay, and before we get to the lien reviews, a few words about what will take place today. Each case will be called, and at that time, if you could come up to the lectern that would be on your right and state your name and be sworn in by the board clerk if you are planning to give testimony. All right, because the testimony in these proceedings is under oath. And then at that point, the representative of the city will be at the lectern to your left over on this side and will provide the details of the city's case or the matter that is being heard relative to that, whether it be a lien review or a case or a compliance matter. And then you will be provided with as much time as you would like to respond. I like to give you as much possibility to explain your case. There are things that may or may not be known to the inspector. They're definitely not known to me. I don't know, most of these cases are new. I've not heard them, and so I have no familiarity with the details of them other than what is provided to me. And there may be things that you may want to fill in that may relate to how the case is ultimately decided. Okay, so at this point, I'd like to have all the city representatives who will give testimony come forward and be sworn in.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
All right. We will begin with the first lien review, CEB 12-19-295, property being at 1808 North Halifax, owners Luigi and Andrea Sarasuoli. At this time, there is an amount due of, with the fine, interest, and recording fees of $18,702.12.
I believe she's appearing via Zoom.
Hello, good morning. Actually, my name is Andrea Cheraswoli.
Gotcha. We can't see you, sir.
Oh,
you
really?
Turn on your camera.
How do I fix that?
Gotcha. There you go.
Oh, okay.
Could you state your name again, please?
My name is Andrea Cheraswoli.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Jones?
Do we typically ask?
Oh, that's right. Mr. Sarasoli, since you're the petitioner in this matter, if you could state why you would like or why you are requesting a reduction in the amount of the lien on this property.
First, I'd like to say good morning, and thank you very much for taking the time out to discuss this matter. I was unaware of a lot of the local laws and local ordinances in the Daytona Beach area. My father, Luigi Cheraswoli, he passed away a few years ago, and the home was his. And he took care of, he knew all the ins and outs. He took care of everything every year. I didn't know. When he passed away, I was just catching up with all of his unfinished business, all of his bills, closing out what I had to, readjusting to life without my dad, helping my mom out with the same. Um, the code enforcement people there said that they spoke to me. I honestly do not recall. Like I said, there was just so much going on at the time. I just it took a while for me to clear up a lot of unfinished business. If there's anything that can be done today, or anything you could do to help me either reverse or reduce this fine would be greatly appreciated. At this time, unfortunately, can't afford to pay such a large bill. One of the reasons why the home is for sale, and anything you can do would be appreciated. Again, thank you for taking the time out.
Okay. Mr. Jones?
Yes, Mark Jones, supervisor, field supervisor with the city. My credentials are on file. This case opened back in July of 2019 for not having a rental license. On December of 2019, I talked to Mr. Sarasoli and informed him of the need for the rental license, and even emailed him the rental application and the rental checklist. The case was before the Code Board in December of 2019 and found a noncompliance. On January 8th of 2020, Karen Baum, who was the rental technician, talked to Mr. Sarasoli and advised him that she had not yet received the rental application. On January 9th of 2020, the case before the Code Board and a fine was ordered of $100 a day with a max of $15,000. The property owner did not attend either of the hearings, and on February 4th, 2020, Mr. Sarasoli called me, and I explained what went on at the hearings, informed him that there was a fine being levied, and that we had still not received the notice, the application for rental. I had no further contact from the property owner until March 18th, 2024, where we had a lien review with the staff. He stated that he had finally stopped renting about a year ago and now had the property up for rent. With continuing to rent the property since 2019 without a rental license till sometime approximately in 2023, staff recommends no reduction in the lien.
Okay.
You said get it up for rent, did you mean up for sale?
Excuse me, he has just put it up for sale, yes. I'm sorry. Thank you.
Okay. Mr. Jackson, do you have anything you want to add?
No, I think that's it. We rely upon hardships. He, at least by the appearance, was receiving rent and had the knowledge of the violation and the lien imposed. I'm looking back at the December minutes, and it appears in those minutes, don't lose my place here. I think it was 2019, the inspector said he made contact with him. If I recall, I'm better find it now. But inspector indicated he made contact with him and told him what he needed. It wasn't taken care of, and that's what resulted in the fine being imposed. December 12th of 2019, respondent was not present. Mr. Jones stated he had contact yesterday with the owner, and it is a joint owner between him and his father, and he said they will apply for the license. He stated he is asking for a fine at that time, a finding of noncompliance, and the noncompliance was granted. And then subsequent to that, ultimately a lien was imposed. So from the city's perspective, he had all of the opportunity, and we generally don't at least make a recommendation of reduction solely because of expressed economic hardship, especially in a circumstance where the property was earning, or at least has the appearance of being an income-earning property.
Mr. Sarasoli, do you have any further response?
I live in Brooklyn, New York, and I hadn't gotten any in the last 5 years. I don't recall getting any sort of notices in the mail. So I apologize again. It may have slipped through the cracks if I did speak to someone 5 years ago. Like I said, so much going on. I'm also a small business owner up here. So many other things going on, and I don't know why it slipped through the cracks.
Mr. Sarasoli, things apparently slipped through a lot of cracks because the process is that you are first found in non-compliance. And at least it appears to me from the minutes that you had contacted the city and said you were going to bring the property into compliance. You didn't do that. Then the next step is to assess a fine. A fine was assessed. The property wasn't brought into compliance. And here we are 5 years later, and you are now saying that there is some equitable argument, and I don't see one. So therefore, I'm denying this, your request for a lien reduction. So therefore, in case CEB 12-19-295, respondent being Luigi and Andrea Cirasoli for property at 1808 North Halifax Avenue, I hereby order the lien request made in this matter to be denied. Thank you.
Thank you, sir.
Next matter is lien review 2, RTL 04-1980, 344 Pierce Avenue. The owner is Leslie J. Tiffany, and the amount currently due is $4,724.
I believe we have Miss Tiffany on Zoom, and we have her property manager here. Savannah.
Good morning.
Thank you. Miss Tiffany, can you hear us? We can't hear you.
How's that?
There you go. There you go. Could you state your name, please?
Leslie Tiffany?
And Savannah,
Savannah Moeller.
raise your right hands. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay.
If I could, Mr. Reggio, staff has met with both Ms. Tiffany and the property manager, and it is our recommendation that the lien be reduced to $2,000.
2,000?
Yes.
I'm okay with that. Is that
Yeah.
correct? Ms. Tiffany?
I agree to that, yes, thank you.
Okay. Therefore, for lien review 2, RTL 04-1980, property being at 344 Pierce Avenue, respondent Leslie J. Tiffany, I hereby order the lien in that matter to be reduced to the amount of $2,000. And now here's the catch, subject to being paid within 30 days, or the fine will revert back to the original amount. You understand that?
Yes.
Okay.
Yes, yes.
And if you run into any problems, please contact Mr. Jones, City Attorney's Office. You'll have no problem getting to somebody and let them know of a problem. Don't come back and say, well, I couldn't make it. And,
Yeah.
and that's fine. Okay,
Thank you so much.
Thank you very much.
All right. Lien Review 3, RTL 04-2331, property at 611 Winchester Street. Property owner Kathleen Hanna. The amount due is $16,374. Do we have a respondent present?
I am here, President, Your Honor.
Could you state your name, please?
Kathleen Hanna.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, Ms. Hannah, if you can state the reasons why you would like to see this lien reduced.
Okay. Again, my name is Kathleen Hanna, and my partner and I bought this house brand new in 2008 for a second home. We paid our taxes to Daytona Beach in Florida since then. I have been a resident since 2008. That's 16 years. My partner decided for health reasons to live at the house permanently. After he died, I came and emptied the house and was going to sell the property, but a neighbor's sister begged me to rent it to her. After COVID, Daytona Beach was looking for new renters and contacted me to pay a beach residential rental fee of $100, which I complied with immediately, and it was even sent to my house, certified mail. Per the receipt that I was contacted by Enzo Bagazzalio, an inspector, that he would be inspecting the house and needed to be inspected once every 2 years. He asked me a series of questions regarding the house and also asked me for the phone number of the tenant in case he was running late. I supplied him with all the tenant information and sent the tenant all the information on what they would be looking for upon the inspection. And so he inspected the house and said that he found a few things that needed to be addressed and that he would have to return in a couple of weeks. After about a month, Mr. Enzo never called or returned, so I started calling him. The first time he did not answer the phone. The second time I called him, he answered the phone and said he would be out the next day. At that point, I contacted my tenant, gave him all the information. Mr. Enzo never came. Then I received a call from Cliff stating that Enzo was no longer with them and that he would be handling the case from now on. I gave him all the information on the tenant, gave the tenant all the information about Cliff, and that Cliff would be handling the case. Well, Cliff Enzo was no longer with them. I know the department must have been overwhelmed after COVID and missing a key employee, but proposing a lien on my property and never informed me that it was even imposed. Not only was I not informed, I knew that even such a lien existed. I've been a vice president for PNC Bank before I retired for over 20 years. And I never had a lien against me. Actually, I could never because of my licenses have a lien against me. I don't even have an unpaid parking ticket against me. What could I have done to avoid this action? I didn't know the lien even existed because of the only time I found out was when my realtor told me it was there because I was going to sell the house. We didn't even know what it was for. And taking whoever it was from the department, I'll tell you what, if I'd known, I would have driven down there, went to the department, grabbed somebody, took them to the house and insisted they inspect my house. But there was no opportunity to do that. I asked for information from when Enzo inspected the house and was informed by Mr. Sykes that it was on another computer and he didn't have access to it. I can't hold my tenant responsible for this. She did not lie to me and say no one came and inspected the house when they did. I mean, we are at an impasse here. I don't see where I am responsible in any way for no one ever coming out and inspecting my house and me not even knowing that they were coming out and inspecting my house or what a lien was even for, Your Honor. And if we could, make some kind of decision here that would be fair and equitable. Again, I have limited funds. I'm retired, and so again, I leave it up to your judgment, Your Honor.
Okay. Anything further, ma'am?
No, that's it.
Okay. Mr. Reckenzone?
Yes, sir. Good morning. Cliff Reckenzone, my credentials are on file. In my notes, in my case notes, I tried to make contact with the property owner before the hearing, the month prior to the hearing. The tenant, when I went out to do the inspections on the property, the first inspection was failed by, Mr. Enzo is not an inspector. and he was never out on the property. Steve Cole was on the property for the first inspection the first time and failed the property. After that, I was never accessed inside the house. The tenant kept on postponing the inspections, and when I tried to make contact with the property owner, I got voicemail and left messages, both on 320 and on 39, and the hearing was on 4/3. The city met with her yesterday or the day before. We proposed a reduction of 8,000. She did not accept that offer. At this time, we're not going to offer anything less than no reduction.
Is that what was proposed, was a reduction to $8,000?
But yes,
Okay.
I believe the position of the city has become she indicated an interest in that and subsequently rejected it. And so the city has withdrawn that at this time.
Okay. This property is at what address?
611 Winchester.
Okay. And the addresses for the notices that, as I see in the materials before me from the property appraiser's office, which is what statute, as I recall, provides for proper notice, is 611 Winchester Street.
Yes.
So I'm, Ms. Hannah, I understand part of your argument, and I'm trying to work through this. But part of it is that one of your arguments is that you weren't notified of a lien or on your property. Well, unfortunately, you have a renter in a property, and that is where the notices are sent to. That renter may have thrown those things in the garbage can, for all I know. But that's not the city's problem.
Certified mail, Your Honor, and there was nothing, even for the $100 rental fee was sent certified mail. This lien letter does not say it was even sent. Return receipt requested, certified mail, and also Cliff never left. I did speak with him one time, but he never left me any messages of anything else. Whether he had the right number at that time, I cannot say. But I never got any other messages from Cliff.
Okay. Okay. Madam Clerk, you handle the noticing.
That's what Mr. Jackson and I were just talking about. We did send the notice to the property address, which is what was on Volusia Property Appraiser.
That's correct.
And it did come back as not deliverable as addressed, and Cliff posted the property at 611 Winchester on April the 17th, 2023.
Okay.
And you have an affidavit to that effect?
Yes, sir.
Okay.
What do you mean posted? What is that?
Mr. Reckenzone, can you explain?
When we don't receive the green card signed, we post the property by putting the letter on the building in clear view, and then we also post it at City Hall downstairs, and we also send you regular mail, first class mail.
And you have a copy that it was sent certified mail?
Yes.
Yes.
Then you would be able to forward that to me to see who signed this, because I have to hold somebody responsible for this, I mean, since I'm like totally unaware of this.
These documents are all public record, ma'am, and you can request that at any time.
What I heard was that the green card request came back as undeliverable.
That's correct.
Because who was ever there was either not accepting mail or there was no way for the post office to make contact with anyone at that location.
That's correct. So it was posted per Florida statute.
And so is it your testimony that everything that was required under Florida statute was done to provide notice to this individual?
I personally did not handle this case, but in
Okay.
reviewing the case, I do not see anything out of order.
Okay.
This was actually handled by Enzo, who was a former employee.
Okay.
But this is consistent procedure which is followed by staff, and it has been followed for at least the last 20 years pursuant to statute. That's a question for you, Ms.
I'm sorry.
Uh,
Yes, sir.
Madam Secretary. Okay.
Yes, sir. It is consistent with the process that we have used since I've been here in 2017.
Do you have any notice of when Enzo came out and inspected the house? He did, I mean, I was told that he actually came in the house and inspected the house.
Enzo's not a rental inspector. He was a technician. He stayed inside the building. The inspector that was at the property was Steve Cole. And he showed damages to the kitchen cabinets and damages to the sink due to water damage.
And would I have been made aware of that at any time, or would I have received notice of that, or?
At the time of an inspection, it's required that you have somebody to give us access to the property, and that person be the representation for yourself. That person was your tenant. When we give the tenant the long form, saying all the violations that were issued, that were in violation at the time of the inspection. So at the time of the inspection, the person that was our contact for you was the tenant.
Ms. Hannah, I understand your situation, but also understand that first of all, you are presumed to have knowledge of the city's ordinances. That goes back to Supreme Court decisions a long time ago. And the rental program is part of the city's ordinances. What you have done is something that basically you have turned the control of the property over to the tenant, and the tenant is not notifying you apparently of what is going on, but it's not a game of hide and seek between the city and you. You put your trust in the wrong person.
Well, Your Honor, also.
What I will say right now, and I would like you to give you a choice. You can, the city has offered a reduction to the amount of $8,000, or you may want to talk to the city again, at which time I'd be happy to continue this matter. Or if that's the third alternative, as I will just deny the request.
Mr. Riggio, we've made our best offer.
Okay. So if you want to consider that and then come back another time, that's fine. But right now, the choice is I can either deny it, or you're essentially, the city has made its offer, and I think that's a reasonable one under the circumstances.
Okay, Your Honor, if the offer still stands, then I will accept it.
Okay. Therefore, in lien review 3, RTL 04-2331, property being at 611 Winchester Street, respondent Kathleen Hanna, I order the lien in that case to be reduced to the amount of $8,000, subject to being paid within 30 days, or the fine will revert back to the original amount. Again, if you run into any problem, contact the city attorney or somebody, or office, or anyone, Ms. Barnes, the city, who is the clerk for this board, and let her know of any problem if you run into one. Otherwise, at the 30th day, it goes back to what it was.
I understand.
Okay, thank you.
Thank you.
Lien Review 4, RTL 02-2421, property at 476 Zelda Boulevard. The owners being David Roberto Ruiz Calderon and Stephanie Marie Ruiz Calderon. There is currently an amount due in the amount of $15,000.
Mr. Ruiz Calderon, we can't see your picture there. There you go. Can you hear us?
Yes, I can. Thank you so much.
Could you state your name, please?
David Ruiz Calderon.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay, Mr. Calderon, if you can provide your statement as to why you think a lien review is, or a lien reduction is appropriate. You're the petitioner.
Yes, sir. So, as I stated in a previous hearing,
If the city can, real quick, the city had reached an agreement, if it is acceptable to the magistrate, to reduce it down to $1,500, just for administrative costs.
Okay. If the city has worked, is okay with that?
Yes, sir.
Okay. Mr. Ruiz Calderon, are you okay with that?
yes, sir. We discussed it at length,
Okay.
and that's something I'm
All
definitely.
right. You've discussed it in much greater detail than we will be able to today, and so if that's fine with the parties, then it's fine with me. So therefore, in case RTL 02-2421, property being at 476 Zelda Boulevard, the respondents being David Roberto Ruiz Calderon and Stephanie Marie Ruiz Calderon, I hereby order the lien in that case to be reduced to, is it $1,500?
Yes, sir.
Okay, $1,500, subject to being paid within 30 days, or the fine will revert back to the original amount. You understand that, Mr. Calderon? You have 30 days to pay it, otherwise it goes back to what it was. And if, as I've said in the previous matters, and I don't know if you were listening, if you run into any problem, contact Mr. Yates or the city attorney's office or the board clerk and explain what there's a problem. And they may be willing to grant you additional time, but if you don't, automatically it will go back to the original amount after 30 days, if it's not.
Okay.
Okay,
Thank you.
thank you.
Yes, thank you all.
All right. Lien Review 5, RTL 08-22-164, 801 South Ridgewood Avenue, respondent being Daytona 19 LLC. This is, total amount due is $31,758.17.
Mr. Zarilla, can you hear me? Could you state your name, please? Any of the three of you, can you hear us?
Wilson. Yeah.
I got you. Okay, each one, I need your name, please.
Andy Liu.
Ralph Kiaya.
And Mr. Zarilla.
Wilson Zarilla.
Raise your right hands, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay, gentlemen, this is your request, and so if you can briefly summarize and state what it is that you are requesting and the reason for it, I appreciate that.
Sure. Good morning, Mr. Riggio.
Good morning.
So we are in the process of selling 304 Taylor Avenue. During the title report, there was a couple of encumbrances. During the time, I was only aware of Ridgewood being an encumbrance of $30,000. Didn't even know that fine was there, but I filled out the paperwork that Mrs. Barnes was kindly to be able to provide. And we had a meeting with Mr. Sykes. Initially, we agreed on removing the encumbrance, with a $2,000 admin fee. Then I got a message from Mrs. Barnes about an hour later that they reneged on the agreement that we had made. So obviously the reason we're selling Taylor Avenue is to be able to bring Ridgewood into compliance. Each window costs about $900 to replace over there, and we have about 25 windows to replace. So we just don't have that money. The windows are operable, which is one of our arguments as well. They do open, they do stay open as well. They're just very old. So Inspector Tamango requested that we have them changed out, but we obviously don't have the money. So we need to sell one of our pieces of the property to take some proceeds to get these properties into compliance.
Okay, anything further?
Sir, I'd just like to just jump in with one thing, which is that the windows do open and they stay open, so there's no issue with egress or anything. So I mean, from a safety standpoint, the windows function. They're just wood frame windows, and I mean, obviously new windows would be better. So as Mr. Zarilla is saying, we'd like to create those funds by selling Taylor so that we can fix that.
Okay.
I just wanted to add that.
Just so I'm clear, I remember you had a number of properties, and this property is at 801 South Ridgewood, the one that's here before me today. Where are the windows that are being replaced?
At 801 South Ridgewood.
Okay. I'm trying to understand, you said you're selling the property to generate money to put windows in. Well, you're
Yeah,
selling
we're trying
the
to
property.
sell 304 Taylor to generate the money to then use to fix up 801 South Ridgewood.
So what you want to do, 304 Taylor, does that have any liens on it?
Sorry.
No.
It's cross encumbered.
Okay, it's
Does it have
cross
any
encumbered. Okay.
stand on its own, I guess would be the question.
To my knowledge today, it does not. It did just finish a code case from a tenant complaint, and there were some improvements to the unit. So as far as the rental inspection, that's scheduled to happen, but I don't have any documented violations for 304, 306.
No documented fines,
Right, and no fines.
Okay.
other than the cross encumbrance.
Okay. I recall you all being almost like a monthly segment of our hearing for some time, taking some properties that were somewhat dilapidated condition and bringing them up to snuff.
Yes.
Maybe not as fast as some of the city inspectors would have liked, but still moving forward. And I like to see things moving forward. Now, in this one, you want to be able to sell, which one again? The
304, 306 Taylor.
304 Taylor, but you can't sell 304 Taylor because you're cross encumbered with a lien that stems from 801 South Ridgewood. Would that be correct?
Exactly.
Yes, and Mr. Magistrate, we're also aware that 549 Mulberry is crossed into that as well. I didn't realize till after I filled out the paperwork to remove the encumbrance of 801 South Ridgewood, but it's kind of, it defeats our purpose to bring these properties up to compliance when we're trying to generate some cash to be able to do so, but then they're crossed encumbrance. And it kind of, we're in a losing battle right now. So we're trying to be in compliance with the city and trying to do the right thing. but it's an uphill battle. And like you mentioned, we've been showing up monthly, to try to get this up to code and, on top of the tenants we're dealing with and the hardship and financially that we're dealing with. We just ask that, you give us a shot.
Okay. Mr. Ridgway, if I can be heard.
Please.
And gentlemen, I've been throughout as well as you're aware, Anthony Jackson, attorney for the city. The problem here is they're asking for partial release, but the property that's the subject of the lien is still a non-compliance, at least from the perspective of the city. They don't have an affidavit of compliance. He mentioned Mulberry. I don't know anything about that. So
It's not in compliance.
okay. Inspector indicates the additional property, which he just mentioned, is also not in compliance. The whole premise of an idea of this lien process through code enforcement is that it provides a general lien to the government body, which extends across all property that's owned, with the hopes that it will motivate people to, one, take care of the property that they're required to repair and take care of. There's nothing that guarantees us, the city, that when they go out and sell that property, that they will take care of these properties. These properties have been in non-compliance for a period of time. They mentioned, or at least suggested, as they initially started speaking, that they didn't really know about the lien until it was, but the lien, this was one where we had a lien that was imposed because of the windows not opening, and it was a life safety, and then we had additional lien because of non-compliance. And so I don't know how they know about it. They were here a whole lot. And so the staff is not saying absolutely not. What the staff is saying is we can't see out. I mean, I know what they first spoke and said, 2,000, but when we thought about the whole case, the whole circumstance, and the whole purpose for code enforcement, we couldn't in good faith just say, okay, we'll just go ahead and erase this and hope that they fix the other properties. I know they have good motivation to fix the other properties because they're investors and they would like to see them fixed, and would love to see them fixed as well. I don't have a solution for them until properties are in compliance as far as the recommendation from the city.
Mr. Jackson or Mr. Mango, I've heard 549 Mulberry is still needs some compliance. It's not in compliance.
Yes, it has a record of failed inspection that the results have been communicated to Mr. Zarilla, as well as their, at the time, their on-hand property maintenance person. So I've done thorough walkthroughs at 801 South Ridgewood with failed inspection still on record. 549 Mulberry, same thing, that they're failed inspections.
And there's also 304 Taylor, which is in need of the windows.
304 Taylor, to my knowledge, is not in need of windows. It's the property that they want to sell that is encumbered by the liens, saying that they need that money from that sale to replace windows.
Okay, so if I understand right, there are just three properties: 801 South Ridgewood, 304 Taylor, and 549 Mulberry. Those are the holdings of Daytona 19 LLC.
There are other properties that they own,
Yeah.
505 Fifth Avenue,
115 South Grandview.
and 115
Oh,
South Grandview.
Correct.
One thing to note, Mr. Magistrate, is obviously we came into this kind of blindsided. Obviously, 115 South Grandview wasn't in compliance, and Taylor was not in compliance. So with our track record, getting those properties into compliance should show you that we have credibility to bring them up to code. It's more of a financial issue that we just don't have 20,000 sitting around to replace all these windows. So,
Well, I understand your argument. I understand where you're coming from on this. And if you are successful and you do what you say, then basically you're making an improvement to the community.
right.
Yes.
By taking, I think all of these properties were originally had compliance issues.
That's
Yes.
correct.
Correct.
Now, the question is, you want the lien reduction for 549 Mulberry, or for 801 South Ridgewood, I'm sorry, because you want to be able to put windows into that property. You said you were selling another property to generate
304 Taylor, yes.
304 Taylor.
Which is in compliance.
compliant.
Is there, I would like the city to consider something. If the 304 Taylor, which is now in compliance, had the,
But going, it's not in.
Right, there's, the matter of, it's due for another inspection. It's still registered as a rental property, still tenant occupied to my knowledge, and which was coincidental because I contacted Mr. Chiaya to schedule the rental inspection
Correct.
for that property, and we put it on the schedule, and then subsequently, this got put on the agenda for a lien review regarding its encumbrance.
what I'm hearing today was that 304 Taylor is in compliance, at least according to the respondents in this matter.
Okay.
Whether it is or not, I don't know until you all have inspected it. But would there be some way of taking a lien off of one property such that you could have 4 properties remain encumbered, and the funds from the sale of that property could then be used to enhance those other 4 that still remain in non-compliance?
Yes, that is simply a partial release.
Right.
And a partial release, we do partial release. We do them based upon the subject property, the property where the liens have originally been applied. It's in compliance. And our general process is if a property is not in compliance, that they're not granted a lien. In this circumstance, there's at least 2 properties. He says, look at their track record. The track record is we have 2 properties with liens that need to be resolved.
But we also have 3, we also.
Hold on. And I believe that, and it's wonderful that they have others, I'm not berating or belittling the fact that they're investors. I understand that, and I appreciate that. Maybe they bit off a little bit more than they can chew when they took on that many properties at once. But this has been going on since middle 2022. So there's a point when properties that are not in compliance is affecting the citizens of Daytona Beach. And it's only right for us to be pursuing, at least from the city's perspective, to be pursuing remedying the properties that are affecting the city in a negative way.
Well, I'm just tossing out there this idea that they are said that they would like to sell 304 Taylor.
They did say that.
And taking it on what they say, and again, there may be issues we don't know about, but if it is in compliance, to do a partial release on that property. Now, that's not here before me today, but I'm just tossing this out.
Actually, that's really what they're doing. So, I mean, it is really what's before you. They want a partial release, I think. Isn't that
Correct.
Understand?
You're
Yes,
correct.
that's
Mr.
correct.
Jackson, you're correct.
So basically,
You're correct,
it'll
Mr.
be a
Jackson.
partial release on every single one of the properties so that there's no longer an encumbrance on 304.
304 Taylor.
No,
So it'll be based on wherever the primary property, the subject of the lien is. That's the ones that have to be partially released to release that off of those general liens.
Well, is there a way to release only the lien on 304 Taylor?
Yes, as it relates specifically to the liens that are encumbering it, which are only, at this point, only 2.
801 South Ridgewood and 549 Mulberry.
Mulberry was not before you because they didn't put it on the list, but that's a simple modification or amendment if you accept that. So we have Mulberry with a existing lien. We have
801 South Ridgewood.
South Ridgewood with 801 South Ridgewood with an existing lien. If you were to do a partial release only as to as it applies to 304 Taylor, and we've used those languages before. So the lien is released as it applies to 304 Taylor. then that would take care of what's encumbering 304 Taylor right now from our liens.
Well,
So the release of the lien as it applies, partial release of these liens only as they apply to 304 Taylor Street, Daytona Beach.
that seems to be what they're asking for.
Yes, that's
Yes.
correct.
But we have other property here, and so
Right. We have the properties where the liens are that are still,
that are in non-compliance, where it's proper to have a lien against them.
Exactly.
Right.
those liens will remain with
it's-
the language I just expressed would leave those liens on those properties.
Okay, I would like to see, and is, gentlemen, would 30 days create a problem? If you all get with the city and bring something back to me, I have no problem with doing a partial release for a property that is in compliance. And that funds will then be used to repair or upgrade other properties that are not in compliance. It seems like that seems like a logical step. I mean, you've been working with the city, sometimes maybe not as quickly as we'd like, or the city would like, but nevertheless, over the time period, you have generally delivered at some point what you said you were going to do.
Well, Mr.
And maybe not at the beginning, and I know, Ms. Domingo, that we got off to a bumpy start.
Yeah, I did want to put something on record to speak to what I heard Mr. Zarilla and Mr. Chiaya say while they're of the opinion that the windows at property 801 South Ridgewood do open. I observed these windows while I was on site at the last inspection being pried open with tools, being broken by the person that was trying to open them. So I understand the idea of saying, well, we got them to open, but that's insufficient for what we call easily openable or accessible windows for purposes of emergency escape. And
I agree. If you've got to break the window to go through it, that's not an opening of a window.
right.
But
The
I don't
issue
want to
was-
get into those side issues here.
I just wanted it to be on the
I just
record.
want to try and get into trying to get properties improved so that overall the city has more available properties, and these gentlemen have properties that are of value to them.
Can I ask just a couple of questions then, Mr. Riggio?
Sure.
Of these gentlemen. When, one, is there a pending sale or sale agreement at this point, or anticipated time period of the sale?
On what, sorry?
On 304.
On 304 Taylor?
Sell. Is
Yes,
some-
we have a contract, yes.
We're trying to close escrow.
Yeah.
We can't with the encumbrance.
Okay, you have to tell me what that means. When you say you're trying to close escrow, what are you saying?
So we're trying to execute the contract. We have a buyer. He's put money down, and his bank has basically approved everything. So our next step is to release the encumbrance of these liens, because if not, we won't have enough money to clear the sale. We have to pay our bank back, and then we have liens here. So again, this is why we're asking to have that release, and then have some money left over to
Replace windows and
repair.
upgrades.
When is the
Mr. Jackson.
anticipated or the hopeful sale date? Do you have an anticipated completion of the sale?
Supposed to be this Thursday.
Correct.
Yeah.
So clearly within the next 30 days.
Yes.
Yes.
And Mr. Jackson, we feel like we, in good faith, I mean, you know us for a while now, can then take those proceeds and put it right into the windows and send Ms. Tomengo invoice of that. That way, we would like to put it in black and white. In other words, we don't want you to just take our word for it.
What we're finding is the windows aren't taking as long as they were about a year ago, right? So
They were
what's the
taking
time period
forever before, sir. Yes.
I'm sorry?
They were
Say it again?
taking forever before, sir.
Yes.
That's correct.
Okay, so what would your anticipated time period be for actually fixing the windows? What would be reasonable?
I think, and you guys could chime in if you'd like, Ralph, and
Or replacing the windows, I guess is the question, right?
so I would say, with the time lapse in ordering, being that they're not taking so long, 45 to 60 days after closing on Taylor.
Yeah, I think that's fair. I think you might have one window takes longer. We have, if you're familiar with the property, most of the windows are the same size, but there's two that are bigger, like bay windows. Those two may take longer, but
Because they're
I still
custom.
think that's in the ballpark of plausible.
And just clarification for Ms. Domingo's sake and for yours, there are international property maintenance code standards on what windows have to be able to do that. They have to be able to
Yes.
freely move and so forth. So whether that's
Correct.
purchased or fixed, if whatever's possible, but they have to move properly, otherwise she's not going to consider it compliant.
Absolutely.
So,
We spoke at length over 304 Taylor, and I think at this point the three of us understand what everything needs to be up to. So I believe we can do that.
So your best estimate would be that somewhere within the next 90 to 120 days, you should be able to be completely compliant, utilizing the money that you obtained from the sale.
Yes, sir.
Exactly.
God willing.
Yes.
Yep.
If I can have one moment to talk with my staff. All right. Ms. Ridgio, we have a thought, but I think we're probably going to have to take a few moments with them before we can actually lay the whole thing out. I guess just from my questions, you know where I'm going here. They're talking about 120 days. I'm left with understanding that whatever we would agree on would be with the same right to be limited right for it to have it revoked if they don't meet the certain requirements. So let's say it's so with the revocation clause. So if in 120 days it's not in compliance and all of that, the lien reverts, or reversion clause is what I'm looking for. Lien reverts back to the original amount. Of course, by then 304 is now clear, and it will remain clear, but every other property would take on the remainder of the amount that you had taken off of 304. The reality is it's already there, though, so that's not making sense. So we have to talk this out and make it make sense. There's no real, and that's what we struggle with. There's nothing that compels them other than their word, because there's nothing else we can do. Now, I will say this, they probably will be motivated with the interest of being able to ultimately release the rest of these liens, reduce them. So we realize that now we're talking about $60,000 in liens. When they add up Mulberry, Mulberry has $30,000 of its own. So they have two properties with $30,000 in liens on them already. And so there's a lot of things to talk about if they want to get this all figured out. It's not as simple as they want it to be, because we have properties that are affecting value, health, safety, and welfare in our city.
Gentlemen, let me toss this out. Is there any way you can talk with your purchaser and get an extension on your contract to allow you time to talk with the city and the city to work out the details of what it would like to do to hopefully make all of this work? And then next month, this matter could come back and basically be ratified if you work out something?
Well, Mr. Magistrate, the concern is we lose the buyer and then this becomes, we're back to the
Yeah,
starting
moot point.
point again.
Right. So ideally, we'd like to figure it out now. I mean, like I said, our track record of, we basically inherited 5 properties in non-compliance. 3 out of the 5 are in compliance at the moment. And we're not shying away from correcting this issue. We're genuinely don't have the finances to do these. And not to say we've done other work that we have not called in Mrs. Temengo to see yet, because we want everything in compliance before we waste their time. So there has been other things that have improved the property's interior, you know, to make them safe and so on. But we're not going to call in to do an inspection until everything is rectified. So we have been putting a lot of our money into it, personal money that's being collected in rents. So, you know, and it only adds value to our properties, you know, which when we do decide to sell, it's only going to help us. So it only benefits us to correct these, get them in compliance, and build some more equity into them.
Mr. Reggio, I have a question, if you don't mind. And maybe I'm being too simplistic, but if we, like, say, I'm just throwing this out there, yeah, obviously it's up to you, but like, say we take 30 days, you tell us you have 30 days to get an invoice and send it to Ms. Temengo so we can see in black and white that we are going ahead, excuse me, with buying the new windows. Would that be, because I understand Mr. Jackson's concern about motivation. So, I mean, like from my perspective, I just think, okay, you know, we have the $60,000 lien in front of us, so of course I'm motivated to do the right thing. It's good for us as far as the future value, and it's also good for us to get into compliance. So for me, that's obvious, but I understand that you are not inside my head. So I'm thinking, like, what can we do to kind of prove to you that we are indeed, you know, of our word? So would it make sense to have like a time period where we show you that we've bought the windows and kind of, you know, break down the timeline and show you the money being spent, et cetera, as a kind of proof, for lack of a better word, that we are doing what we're agreeing to do?
I think I can make it simpler than that and give an offer, Mr. Riggio, if we're willing to. I think staff is willing to go here.
Let me ask a question that now I'm starting to see. Y'all want to sell 304 Taylor. There are,
Yes.
That property does not have a lien on it, but it is affected by liens on 801 South Ridgewood.
Correct.
Well,
Is that
Mulberry.
but what about 549 Mulberry?
Is affected by that as well.
So
separately.
Yes.
we're not really solving the problem if we take away one of the liens at this point.
Unless you amend their request to address both of them.
Well,
Yes.
unless they're planning to pay off 549 Mulberry as part of that sale transaction.
Ideally, we'd like the time to get them into compliance. Again, the whole point of selling Taylor is to free up some cash and do this work.
Yeah. Right now, they're
So-
not telling us they plan to pay off anything. I mean, as far as it relates to liens, they're only telling us about their plan to bring properties into compliance.
Yeah,
And
I'm just,
I don't know what Mulberry needs, but no one's talked about what the compliance would be for Mulberry.
Correct, but we're planning to, you know, when the time comes to pay that, Mr. Jackson. Like, I mean, as you know, as you guys deem necessary, we're not trying to run from that. We're just trying to get the funds that we can put it into compliance to then have that discussion.
The ultimate effect, Mr. Riggio, is that right now there's 60,000 plus liens encumbering 304. And under our normal circumstances, we would not even consider a lien review. However, there are a number of other properties that will remain encumbered, so we understand that. And I guess the leverage, if we want to call it that, would be that if they didn't do what they did here, that would be strongly considered as if they were to come and ask us to address the future liens. Maybe we would, maybe we wouldn't. But maybe they won't even need to ask that because they're going to get so rich once they get the sale done and get the properties together. But whichever way. I'm not supposed
That's,
to.
if only.
I wish that was the case.
Here's our offer. Our offer is, we're talking now $60,000 encumbrance on 304. We're willing to reduce the encumbrance to $6,000 that they pay for 304 to clear it, and I can tell you how to write the order that would say that 304 is clear as relate to the two properties that's encumbering it, and that would be, you know, the liens as applied from such and such and such and such is now released. It would be as a partial release from, so we'll have to cross it. We've done it before, and it just has to be clear enough that someone looking at a public record knows what happened.
That's correct.
And of course, a title examiner is satisfied with it, when they're, you know, in terms of, and I think we can do that in terms of the way it can be written. So we're willing to, basically that leaves us saying, we're going to trust them that in 120 days, they're going to have these properties together based upon the things they're doing or they're promising to do now. And our only real leverage, our only real effect on this is that we have remaining properties that will still be encumbered by this 60,000 plus, which could possibly be more if other properties aren't resolved. And that the willingness to even consider adjusting that in any way would be based on looking at how this goes.
Right.
Okay.
That makes sense.
So that's the best we got.
How do you want that expressed in an order?
I believe
Good
that would be a
question.
partial release by name.
Yeah, and I think we've done it before. It may even be one of the form orders that we have in terms of just general partial.
Yeah, we've done that.
Do you have one available?
Right this minute?
Yes.
No.
I want to make sure that I dot i's and cross t's on this one.
Hey, can I ask Mr. Jackson if obviously
Not a
Andy and Ralph, are we good with that?
I'm sorry, say that again?
Yeah.
May I ask if we do,
I don't have any releases.
I think we're okay with the 6,000, but if we are in compliance before the 120 days, can we work with that 6,000 to help us with the 60,000 liens on those other two?
Can that go towards?
Can it apply
Yes.
forward?
Okay. We don't know where your totals lie ultimately, right? But when we get to the end, we will have to recognize that as it relates to those liens that you paid 6,000 somewhere. So when we look at your totals, if we're at, 60 plus with interest, yeah, we'll recognize that we're subtracting 6,000 previously paid off of that.
Okay, I think that's fair and holds us, everyone accountable.
Yeah, keeps us motivated.
Yeah.
Okay, so partial release. Okay, now I have to figure out how to write this order. So by the time we end, maybe you're gonna have to come back or hold on so we can, I'd ask if we could pass, and by the time I end this, I'll figure out how to write that.
Okay.
Gentlemen, does that work for you? I want to make sure, because I want to have the order so that I can read it into the record.
Yes, sir.
And so that anyone who is listening in or will see what has transpired. But the bottom line is to try to take where we've got two properties out of compliance, 3 that are in compliance, and to use money from this non-compliance property, or use the money from the sale of a compliance property to essentially bring more properties into compliance.
And I'm sorry, go on.
And I just want to be sure that I'm clear on that, just as anyone else would be clear if they
what I'd like to do is, and first I apologize very much to the folks that have been waiting and are waiting. But if I can just take 5 minutes, I can run this over to my paralegal and she can start working on what makes sense. She does this all the time for me, and she will be able to see if we can have something by the end of it. And if she tells me somewhere that something I'm saying is crazy, she'll help me get it uncrazy. So if I can take a moment to just run that over to her, maybe a 5 minute, just.
We
no,
usually
5 minute.
take a break about this time for about 10 minutes.
And then still, that means you guys will still need to be on hold or make a return later, which could either be by phone call or.
Yes, sir.
Hang on
Yep.
in a waiting room.
Okay?
Okay.
Yes, sir.
So why don't we do this? We will go into recess for 10 minutes. So it being 10:18, I hereby call this proceeding to be in recess for 10 minutes, and we will reconvene at 10:28.
Here you go. I already texted her, Tony. We're good.
Oh, I was watching.
That's one?
That's a sample.
Hey,
Teacher.
Rafi, there.
Are you ready back there? All right.
Are you ready?
The screen is still, there we are. It is 10:39, and I call the March 26, 2024 Special Magistrate Session back in order. We had previously taken a break to try and work out the details of with respect to the lien review for RTL 08-22-164, 801 South Ridgewood Avenue, property owned by Daytona 19 LLC. Mr. Jackson, are there still some details you're trying to work out?
Ms. Ridgey, I believe we can do this. I think the real, typically what would happen is that the respondent.
Is the respondent on?
Oh, they're not on yet.
Can you put the respondents back on? There they are.
There you go. 1, 2,
And Mr. Zarilla?
3.
Yep,
There he is.
I'm here.
Okay. We called the session back into order a moment ago, and the city is preparing some paperwork. And let me just say, in the future, I like to see private money or fine money which is being used to go into resolving issues, because public money, from what I've heard over the years, is just not readily available for a lot of this. And so this accomplishes a good for the city, which is sometimes what fines are about, to try to get people to do the right thing and make the city a better place.
Absolutely.
And so I like trying to do things sometimes maybe a little creative, a little out of the box, but it is also good if these things can be resolved before the hearing, because there are other people who are waiting for their cases to be heard, and this takes up sometimes what might be, from their standpoint, an inordinate amount of time being spent on one item. And Mr. Jackson, do we have something now in order, or is there additional items you need to look into on this?
No, we believe we don't have anything additional to look into, but we do have additional things to address, and so just want to address them with magistrate as well as the applicant. Typically, on a lien review, what we get is someone who is asking for a reduction or a partial reduction as relate to, specifically with partial reductions that relate to something that may have shown up on a title report or something to that effect, or came from an inquiry of the city as to what liens are actually on the property. What we've discovered just in this period of this brief break is that we have 2 liens on the property at 801 Ridgewood, as we had stated before, and there's 2 liens on the property at 549 Mulberry, which we stated before. We're also showing a lien, though, on 115 South Grandview, and I don't know if they still own it, didn't own it, but it appears to be encumbering this property as well. So basically,
that lien has been paid and cleared.
It's possible.
Okay, all right. If you believe it's paid and clear, we won't address it, but at the same time, us not addressing it leaves it hanging out there. Or we could address it on the assumption, the intent of the order being that it not encumber this property, if it should exist. So with that being said, Mr. Ridgeo, what we propose, what we typically do is the announced effect of a lien reduction is what you announce, and that's usually recorded by the secretary as part of their request, and it's not the exact same language of a release. But we do have a model, and we have done these types of release before. In fact, we just resolved a case a few days ago that was one that had this type of a release. The order would say, and I'm just going to give it to you brief because I want to be able to come to you and show you because it is complex. So what I have written is even more complex, the way it's written. So I want to show you how I have it written. if you want to make that announcement, or if you want to just adopt what I announced.
No,
But
I want to announce it. I also want these gentlemen to hear it as well, so that they know what it is, so that we're all on the same page.
Please.
Okay, so this is the order I'm proposing. That we order that the property encumbering, the encumbered property 304 Taylor, let me say it a different way. The property that is encumbered, 304 Taylor Street Avenue, or whatever it is, Daytona
Avenue,
Beach, by the okay. That is encumbered by the following orders imposing fine lien recorded on book and page. And we mentioned book and page of each one, so it would be the book and page of 84004 page book, 8404 page 3947. And it would be book 8388 page 1821. That would be as to 801 Ridgewood. And then it would be book 8378 page 1283 or 1283 for and then also book 8378 page 1280, which would be the ones from 549 Mulberry. And
If I heard right, there's another.
Right, and then
I don't see why that we can't include this as well, so that if there is a problem and they don't know about it, it's not going to interfere with their sale.
yes, and so that would be book 8250, page 1987, and that's for the property at 115 South Grandview. So that order would say that those would all be listed, and will say shall be partially released as to the property itself for the amount of $6,000. All other property owned by owner shall remain encumbered.
Okay.
In fact, probably need to say fully encumbered. And then I would suggest an additional, in addition, the parties stipulate to any necessary amendments to clarify this reduction for the title company while accomplishing the spirit of this order.
Okay.
So that's all we would need
Now-
for this to cover these in terms of an order.
Okay, you said that as to $6,000. So is there $6,000 that would come out of the sale of this proceed that would come to the city? I don't know where that's.
We can do it that way. It doesn't have to, if that's the way we want to put it in the order. We're saying, or pay 6,000 within 30 days.
Okay.
It would be the cost to release.
Which will apply, as always, once it's received into our accounting, will apply to any outstanding obligations
Correct.
that they have.
Okay.
We'll split them between the liens evenly.
So
That's fine.
yeah, that's just a simple matter of accounting for us, and that's what we are required to do. Anything that we receive that will be associated specific to the land.
So do you have that written out in a way that I can read or do you want to take a few minutes?
No, I think I have it written out in a way that you can read it.
Okay.
So if everyone else, I know the parties heard, the gentleman there heard this, and if there's anything they want to ask or say about that, I'd be interested if I need to fix anything. I think this is but this is the spirit of what we're asking to do, and I think it would be accomplished. Ultimately, the release itself, we have a standard release. We would provide that. If it causes any problem or heartburn for the title company, we can modify it to make sure we still show the spirit of this order.
Well, I'm sure the title company wants the property released completely.
Yes.
Otherwise, they're going to pay that out of
Absolutely. And I
out of the
believe
sale proceeds.
That's correct. sir.
Correct.
Yeah, and our history of doing it this way does that and typically satisfy the title company. But if there's any hardship at all, we want to make sure, or heartburn, is what I'm looking for. We want to make sure that we have the power to just simply modify it to still accomplish what you intend when you ordered this.
Just again, I'm going back to that 6,000 because is it your intent that when the closing occurs, that the title company lifts out $6,000 and conveys that to the city as a lien that it remains on that property that's being paid off?
Well, it's part of the condition of the release, so, yeah, we can make it as part of the closing.
Well, I'm just saying
We have
that's what your
form.
intent is that,
Yes.
gentlemen, and
Yes.
if I understand that, I just want to be clear on this because it's that you understand that whatever your sale price, $6,000 of that money, if I'm correct, will be headed to the city of Daytona Beach.
Normally,
Yes, sir.
that,
We understand.
that amount is paid in advance before the release is prepared.
Okay.
Normally, I mean, you can do what you want to do, but normally that release, it's paid and then we prepare the release.
So they would come up with $6,000 and pay the city. I want to be clear on this because I'm sure, gentlemen, you want to know what's going on. And I want to make sure you're clear on what's going on.
We do, and sir, it'd be good from the closing that way. That way everything is directed into one space. I think that actually does make the most sense, if that's okay with you.
It's,
And although I spoke,
Yeah, if we can,
go on, I'm sorry.
yeah, if we can have it released from the closing, we just don't have the $6,000 up front. We're pretty confident the property is going to close, whether it's this week or next week. So you guys will get paid regardless.
So I just added to be paid at time of closing.
okay.
Okay, great.
Okay, thank you.
Now, the only other thing, and I don't think it needs to be a part of the order, is just that it's understood, because it doesn't affect anything monetarily, and that's that 120-day period I spoke of. From a monetary sense, it really doesn't affect anything because the lien's going to be there. We can't give any more lien because of it.
Right.
But
And if
it defines the good faith of what they're doing. It's on record. We'll look back and we'll see our minutes and the records thereof, and whatever way we address, if we have to address any of the future liens, we'll address it with the knowledge of how this went.
Okay.
So may I approach and
Yeah.
kind of show you what I think is an easy route through this map of. Okay, so first of all, hopefully you can read this. But so this reads, as I said here, and then when you get here, you're over here.
Okay.
So when you get the booking page, then there's 1, 2, 3, 4, 5. And these are the properties underlined, so you got them. And at least the booking page for each one. Booking page,
Okay.
Booking page, so forth. So you'd announce it for each one, and then the continue shall be released as to those properties itself, or
Okay.
other properties remain encumbered, or fully encumbered. And then this little stipulated point that I just made, and that's a little jig, so you can just see what my jig is there.
Okay.
And, yep, that will cover everything. That's the piece I stuck in a second ago about at the time of sale.
The time of sale.
So, yeah, you can work your way through that, and we're good.
Okay. All right, gentlemen, do you have anything further? Otherwise, I'm going to read into the record my order that reflects what Mr. Jackson just spoke to you about.
Nothing further, sir.
Okay.
I think
Well,
that's
so did I cut you off?
Anything
it's fine.
further?
As long as we can get a release via email so we can provide it to the title company as soon as possible, that'd be great.
Okay. Therefore, lien review number 5, RTL 08-22-164, affecting property 8801 South Ridgewood Avenue, owned by Daytona 19 LLC. I hereby order that the property encumbered by the lien being 304 Taylor, or no. I hereby order the property encumbered 304 Taylor in Daytona Beach by the following orders imposing a fine or lien recorded on book 8404, page 3947. Okay, well, let me just go back again. This is why I like to see these things done in advance, but I'm going to start over again, gentlemen, just so that we have this.
No worries.
Okay, we are, I'm now, with respect to lien review 5, RTL 08 22-164, property at 801 South Ridgewood Avenue, owned by Daytona 19 LLC. I order that the property encumbered, 304 Taylor in Daytona Beach by the following orders imposing fine lien recorded on book 8404, page 3947, which would be RTL 08 22-164, and the order imposing fine lien recorded at book 8388, page 1821. Then the next order imposing fine lien for 549 Mulberry, that is RTL 08 20-22-163, recorded at book 8378, page 1283, and order imposing fine lien recorded at book 8378, page 1280.
Right.
And shall be, and order imposing fine lien RTL 11-21-235, recorded on May 3rd, that can't be right. 2022, at book 8250, page 1987, relating to 115 South Grandview, shall be partially released as to the property itself for the amount of $6,000 to be paid at the time of closing. All other property owned by the owners, which is Daytona 19 LLC, shall remain fully encumbered. And in an additional sentence that says parties stipulate, or the parties to this parties stipulate to any necessary amendments to clarify this reduction for the company while accomplishing
For the title company, I'm sorry.
for the title company while accomplishing the spirit of this order. Does that work for you, gentlemen?
Yes, sir.
Yes, sir.
Mr. Jackson,
Yes, sir.
do you
Yes.
have any further changes you want to make to it?
No, that's great. The only thing I want to say that I'm, as far as that, ask for the release in advance. What we would do normally is probably, we can stamp one for you as copy, but have your title company contact us and we'll send it directly to your closing agent or title company. Is that
Okay.
okay? Can that
Okay,
work?
great.
Okay.
Yeah, we just need the release, or
Certainly.
else.
Yeah.
Yeah.
So normally we just send it directly to them so that they make it part of your closing package, since we're relying on the
Okay.
closing for the payment.
They
All right, thank you,
generally
sir.
insist on that it comes directly from us.
Okay.
They will call us if you send it to them. They will still call us.
Gotcha. They need confirmation.
Right.
Okay.
Right.
Thank you.
Understood.
And I would like to have these 2 pages that I read off of made a part of the record of this proceeding. So if there's any questions that arise, and Mr. Jackson, this is the remainder of your pad.
And it's just essential that you guys remember that this, from our perspective, is a test of your good faith in accomplishing what you intend, what you expressed to us you intend on accomplishing, and accomplishing it at a relatively rapid pace. I think within 120 days sounds like a reasonable time period based on what you described, and we'd like to believe that we can see that, and we'll keep that in mind as we work with you further.
Thank you,
All right,
sir.
great. We appreciate it, Mr. Jackson.
Yeah, we do. We appreciate it.
Did we
Jackson, Mr.
include
Ritchie,
that in
thank
the
you.
order that you
I
feel?
didn't feel it necessary, only because it has no real impact ultimately. It can't put more into the lien or
Okay.
anything else.
All right.
So it's just good faith. That's what we're looking at on that aspect.
Okay, and gentlemen, if this matter comes up with any of your remaining properties, please get with Mr. Jackson or the city beforehand so that we can make this go more smoothly at this proceeding.
Yes, sir.
Yes,
Makes
sir.
sense.
Thank you very much, sir.
Thank you, Mr. Magistrate.
Thank
Good
you,
luck.
Mr. Magistrate.
Thank you, Mr. Reggio.
All right. We now move on to the hearing of cases, and we have some new cases. First one being case number 1, RTL 032433, CC Post House LLC, trustee in Florida Land Trust, S612DTD 8/31/2015, either trust or trustee, is failed to correct violations of city code at 612 North Halifax.
Okay, that's fine.
Mr. Reckenzone.
This, it's a new case, so you just can withdraw it, that's all.
Yeah, we're just going to withdraw this case.
Mr. Reckenzone, you wish to withdraw the case?
Yes, sir.
Okay.
Then I hereby order that case number 1, RTL 032433, respondent being CC Post House LLC, Trust and Florida Land Trust S612DTD 8/31/2015 Trust, is hereby withdrawn. All right. Second case. This is a continued case. Case number 2, RTL 022425, TRSTE LLC, Trust and 433 Marion Street Land Trust, cited for failure to correct violations of city code at 433 Marion Street. Ms. Tomengo?
Okay, since the last hearing, I have not received any contact from the owner. I did verify that this is a rental property. It's tenant occupied. There has not been a rental license application submitted for the property, so I'm requesting a fine of $100 a day, up to $15,000 max, or until compliance is met.
Okay, and to be imposed as of this date?
Yes, sir.
Okay, and once again, let me make sure there is no one here on behalf of this entity, TRSTE LLC, Trust and 433 Marion Street Land Trust. If you're here, please come forward. We have no respondent. So therefore, in case number 2, RTL 022425, respondent being TRSTE LLC, Trust and 433 Marion Street Land Trust, I find the respondent in this case to be in non-compliance and order the, I find the respondent, who was previously found in non-compliance, remains in non-compliance, and therefore order a fine in the amount of $100 per day to commence on March 26, 2024, and to continue each day thereafter until the fine has reached the amount of $15,000 or the property is brought into compliance. Okay. Thank you.
Thank you.
Okay, we had moved on to the irreparable and irreversible matters, and first case there, case number 4, RTL 032428. Respondent is Esther G. Adams and Russell John Carter, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 1156 Sand Trap Court. Anyone here on behalf of the respondent? If so, please come forward.
Are you sure I'm ready? Because case 3 was before me.
Case 3? Case 3 was already in compliance as of today, so they don't have to be heard.
Didn't want to go.
No, that's fine.
Okay.
Come forward.
Could you state your name, please?
Esther G. Adams.
And raise your right hand.
Yep.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you.
Mr. Yates.
Kevin Yates. My credentials are on file. The case before you is a zoning violation. This case was field generated. The property is zoned PDG. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed February 13th, 2024. They were notified the same day. The property stopped actively advertising as of February 13th, 2024. The daily posted rate was $168. The check-in, check-out time were shown as 3 p.m. and 1 p.m. These actions are irreparable and irreversible in nature and due to the actions of the property owner requesting a one-time fine of $1,000.
Okay. Mr. Jackson, do you have anything to add?
Yes, sir. Again, Anthony Jackson, attorney for the city of Daytona Beach. This time I typically will bring forth, and I would like to bring forth to the magistrate, the position of the city as it relates to our request that these violations are determined to be irreparable and irreversible in nature as provided in Chapter 162 of the Florida statute and Section 162.09, subsection 1D. Everyone that's listening that have these types of cases, the short-term rental violations, if you're online or wherever else and you're able to hear this, this is something I will introduce in each case, and you will have the opportunity, if you so elect, to have me introduce this again, or have the ability, if you desire, for me to waive hearing it again, and you'll also have the opportunity, if you so elect, to address any of the things that I've raised as the city's position regarding the violations being irreparable or irreversible in nature. So the city feels that these are irreparable and irreversible in nature because there's a beneficial gain to the property owner who is advertising conduct that is prohibited by the city's code. And this conduct affects property, and it's property that's being rented or being held out. It's property as vacation rentals that cannot be reversed or repaired. The property is advertised worldwide, marketing a destination that draws people from all over the world for principal special events such as the Daytona 500 races, Bike Week, Biketoberfest, and throughout the spring and summer months, to our world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney World and Space Coast. Once the properties are advertised, they're never truly unadvertised. The reality of the World Wide Web is you can't push it back into the tube. Information posted today can be printed and saved, forwarded, retweeted, and even copied and posted on other sites. So that limits the city to the only solution for the advertisement is to require that all postings be removed. SmartSightings.com marketing website provides that as of October 2023, there are 4.95 billion people around the world use social media and can be reached by advertisement. The information has effects on patrons. The long-range effects are that under contract to participate in an unlawful stay in our city, the patrons risk poor health, poor safety, and poor welfare due to unregulated or self-regulated vacation accommodations that the patrons enter into at their own risk. One single day of advertising can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspections, proper licensing, proper insurance, and proper taxation required by law. The transit nature of the rentals limit the means of the enforcement, typically to identifying advertisements. By the time code enforcement arrives to properties, the transient patrons typically are gone from the property, or they claim some misleading relationships that are often contradicted by the advertised visitors' comments. The monetary effect of these unlawful rentals is a tax avoidance, even though many places are getting the state or county, the city taxes or the city obligations are not covered. Inadequate insurance coverage, unfair business competition against the lawful accommodation businesses and the lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from traditional and reliable residential norms. There's a demand from the business community to our commission, which has led to a request for a strong deterrent to those who are raking in profits, avoiding state and local taxes, avoiding zoning requirements, and regulatory controls. We've all seen rentals go for amounts as much as several $1,000s a week and realize substantial fines is the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. So state law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or irreversible in nature, whether they're by advertisement or by individuals actually being at the property. And we also ask that you look at the gravity of the violation and that some of these violations are, the longer they're advertised, become more of a negative effect and more of a incentive for profit to the owner. And so when they're advertised for lengthy periods of time, we tend to ask for the maximum fine of $15,000. Over time, you have, Mr. Magistrate, considered lesser fines based upon circumstances where someone has immediately responded to the request that they come into compliance. And so with that being said, the city is, again, asking you to make the finding that these are irreparable and reversible in nature based on our position.
Okay. Anything further?
And I have nothing further, Mr. Riggio.
Okay. Right. Ms. Adams?
Yes, I agree with everything you've said, 100%. Thank you. Probably not being educated. I honestly did not know I was in a PDG. I'm sure you hear that often. But a stupid mistake was made, and I was in compliance with less than 24 hours on everything I was supposed to do, to cease and desist, did everything that was requested of me in 23 hours probably or less, and kept in touch with Kevin constantly, probably too much, to make sure that I wasn't in compliance. So nothing was ever come out by posting it on Airbnb. There was no contract, no move-in, no monies exchanged, nothing. But again, I understand what city attorney is talking about. And all I'm asking for is to be educated. So I have been in touch with City Commissioner and Mr. Sykes to try and help this situation for people to be educated. First violator, I know it's irreparable and irreversible. Maybe it could be a notice. You have 3 days, 5 days to complete it, get everything done you're supposed to do, versus getting a irreparable and irreversible should be for someone who is someone who does violations more than once, versus a first-time violator. I just want other people to be educated. That's all. I'm fine with the fine. I just want to help others that do not know, like I was in that situation, honestly, did not know. I just want to help others.
Okay. Thank you. Okay. Ms. Adams, when we initially, this goes back now, or when I started hearing these back in 2020 or 19.
Mm-hmm. Long time.
COVID, yeah.
The city commission was of an opinion that these were egregious problems because of the citizen complaints I am sure there are many vacation rentals where people mind their P's and Q's and just act like any other member of what is essentially a suburban community, because that's typically where I've heard most of these come from. And the people next door who have to get up to work or go and do something were raising a hue and cry about the fact that, oh, these people were partying all night long at the house next door.
Mm-hmm.
Or there were a number of them during event weeks where essentially the police became the night managers for property. And typically there was also alcohol involved, and that creates a very volatile situation. And the feeling was that this is something that has to be kept under control, and as a result, the fines initially levied were $15,000 across the board. And I have moved things back from that over time. I'd also been hopeful that maybe the legislature would do something this year. There was a Senate bill that passed.
SB 82?
And the House bill, if I understand correctly, basically reflected a lot of the bigger cities who were adamant that some control has to be put on these because their citizens were getting so many complaints. And that didn't reconcile with the Senate bill, so once again, nothing was done. But that's clear from the House bill that there is a perception in, I think it was Miami and Tampa and down in the Naples area, which are prime locations for vacation rentals, that their citizens were fed up with vacation rentals. And my understanding so far, and I've not heard anything different, the city commission wants to make sure that we try to, that there's, since vacation rentals are two violations. One is they're a rental. And if I understand, almost any rental of property in Daytona Beach is subject to some type of regulation because there are vacation rentals in the city. And those people have to get a license, they have to be inspected, they have to have smoke alarms, and all those good things that go along with rental properties. Vacation rentals, so those are covered. Long-term rentals are covered. Everything's covered except the people who choose to sidestep all of the rules. They don't get a rental license. They can't get a vacation rental license unless they happen to fall in one of those small areas that allow for vacation rentals. And so I have not seen necessarily a need to drop the amount of the fine below $1,000. And Mr. Jackson, is there a hue and cry to reduce the amount of the fine? I try to reflect what the community is looking at in terms of the egregiousness or the concerns about a particular type of activity. And I would like to have thought that when I was levying fines of $15,000 back, that this would just come to an end and that would be the last time I hear. But here we are now 4 years later and people are still doing it. I still have a list of cases every month of people who are doing short-term rentals, and I understand it. I see Mr. Yates and his predecessors would go on about the nightly rates. I mean, people are renting out their houses for $400, or if they're a big house, $800 a night. This can be very lucrative. And I'm not seeing I'm seeing that all of the factors that related to my trying to bring this down to 1,000, I'm starting to wonder if whether we should have stayed at 15,000 and just said it's something that everybody should know is wrong. And hopefully the word would get out more, and maybe people would, if they knew they were facing something like that, would choose it. And so I'm
not asking to lower the fine. I'm okay with the fine. What I'm saying is people that don't know need to be educated, just need to have a little bit more information when they're purchasing a home. If, do you know that you're in this certain zone? Do you know this? Do you know that? Are they educated at all? Is there information enough out there? That's all I'm saying.
I don't disagree at all with that. And
and that's where I want to come in. I want to come in to try and help. That's all I'm saying. I'm okay with the fine. I just want to help others who are clueless. That's all.
And I'd follow up on that, and I would say that
I am.
From over the years, realtors seem to get involved in this in a big way where, oh, you can own a house in Daytona Beach.
I know.
And you can have your mortgage paid off.
I know.
While you rent it out, and then when you retire, you come to your paid off home.
I know.
They should know, and I don't know if anyone from the city ever goes down, because I know there's various realtor associations, and just speaks to them and says, because they have meetings and says.
Well, that's what I want to do.
It's wrong. It's not legal in the city of Daytona
Correct.
Beach, except in those little areas where it's allowed. And I don't disagree. Education, whether it's printed on water bills, I would prefer not to hear any of these cases.
I hear you.
I prefer that we focus on things where, people were, especially the long-term rentals, where people may be in substandard housing. Because oftentimes on the vacation rentals, they're nice, really nice abodes, even if they aren't inspected or anything.
I think there's a lot of ways to try and get the information out there.
I don't disagree with you at all on that. You're sort of preaching to the choir at this point, and I would like to see fewer and fewer of these, but yet every month we see a half dozen or more. So if you're not disputing the fine, I will find you in violation, but I'm sorry that you ended up getting led astray by
That's
whatever.
okay. No problem.
Okay, so therefore, in case number 4, RTL 032428, respondent being Esther G. Adams and Russell John Carter for property at 1156 Sand Trap Court. I find the respondents to have been in noncompliance of Article 4, Section 4.1a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 1156 Sand Trap Court. And to have subsequently come into compliance very rapidly on February 13th.
Yes, sir.
2024. And hereby order respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, respondent may be placed on a subsequent agenda for hearing before a special magistrate for consideration of a fine of up to $15,000 as for each occurrence as per Chapter 162 Florida statutes. I'm sorry, ma'am, that
Oh,
you...
no, don't be.
But
That's okay. Thank you.
Thank you.
Okay. We are going to hear now case number 5, RTLO 32429. respondent being Tizayan Berhane Araya, cite for failure to correct violations of Land Development Code Article 4, Section 4.1A, Article 5, Section 5.2.A.2 at 106 Misty Glen Lane.
Could you state your name, please?
Robel DeWitt. I'm her son.
Can you spell, please?
Robel, and last name Dawit.
And are you also testifying?
I'm her son, so
You're
I'll be
and she is,
she is the owner, Sion Berhane.
which is Jishan Berhane.
Sion.
Okay.
Yeah.
Sion?
I know I'm saying it wrong. I apologize. Okay. All right. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned PDG. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed February 24th, 2024, and they were notified the same day. The property stopped actively advertising as of February 28th, 2024. The daily posted rate was $180. The check-in, check-out time shown as flexible and 3 p.m. Due to the actions of the property owner and the irreparable, irreversible nature, we'd like to ask for a one-time fine of $1,000.
Okay. Mr. Jackson?
Sir, as I had indicated before, when I presented the request for irreparable, irreversible finding, that if you like, you could waive that. If you don't need me to read it again, if you need me to read it again, I'll be happy to advise.
No, we were here. We heard the whole thing.
So you okay with it being waived?
Yeah, you can wait.
Okay. I'm going to ask you to go ahead and pull that mic up a little so we can make sure we hear you. You don't have to bend over and hurt your back. There you go. I think he has accepted waiver of that, me reading this again, so I just ask that it be incorporated into this proceeding.
Okay. I therefore incorporate Mr. Jackson's statements regarding irreparable and irreversible, which he set forth in the previous case, RTLO 3-2428, and I incorporate them into this proceeding.
Thank you.
Okay, sir, this is your chance.
Yes. We'd like to ask for a reduction in the fine. We understand why we're being fined, but we'd like to have some consideration for the fact that the property was never rented. We never made any money. We never accepted any offers. There were no offers that were put out. In fact, we hadn't even actively checked for offers on Airbnb for the past 3 or 4 months. We just forgotten to take it down, neglected to take it down. And we understand that advertising itself is just as much of a violation now as having someone in as a short-term rental stay. But there were no transactions on this account.
Okay. Mr. Yates or Mr. Jackson?
I didn't see anything to contradict that.
Okay.
I guess the unfortunate thing is that's often, especially with those that are immediately responsive, that's often the case, that there is no transactions, and it really leaves the magistrate in a position of just trying to understand or read an intent, which sometimes is very hard to do. The city's position is one of we're just consistent in understanding. I mean, it's not an expressed hardship necessarily, but just an expression of something that really is a common occurrence. And so with that being said, I think we're pretty much from the city's perspective left to maintain our recommendation. Of course, it's always within the consideration of the magistrate to respond as you see fit, but the city's position will remain the same.
Okay. Sir, my problem is...
I think she wants to speak.
Oh, please do.
And just get close to the mic, please. There you go.
Okay. Thank you. I just wanted to explain that, I don't live here. I don't stay here. I just got this place once or twice a year. I usually come here. That's why I bought the place. because I don't even live here, and I don't even have any awareness that I cannot rent this stuff, because I'm not from here. You know, I just got this place to use it just once or twice. So in between, I told my son, just if he can do it, because I was not aware. If I would have known that I cannot rent it for a short term, I wouldn't even have bought this place, to tell you the truth. Because, you know, for me, I stay here on summer for 3 months, because my son, he's a student, he goes to the university. Nobody is there. That's why I asked him to rent it, because I didn't even know that I cannot rent the place. When I got this place, like a year before or something, if I knew that I cannot rent it out, I wouldn't have bought this place in the first place. So I'm really sorry, because I was not aware. I'm not from here.
Okay. All right.
I always say, Mr. Magistrate, sounds like a nice lady and a nice young man, but as far as the city's position, we maintain our position, but it's always within the discretion of the magistrate to handle it as he so see fit.
My problem with this is that, to a great extent, the violation is the holding out of the property. I've been hearing these for years now, and I've seen folks manipulate things, and there is so much money to be made off of short-term rentals. Mr. Yates, if a property is rented, how do you know that it's been rented?
I mean, besides running into people or there being reviews, I don't. And so I don't know when it's occupied, to tell you the truth. We just have to go off the fact that they are offering it for rent, and that's generally how we discover it, not that we 100% know when it is and is not occupied.
And that's the problem I have, is I understand this, but this is also not like a trial where there is discovery and there inquiry. I hear I understand your statements, but I also understand that there are other people out there who would, if they had a chance of trying to reduce a fine, would say that the world is flat and swear to it. And I feel very uncomfortable, because then I have to make determinations that have no factual basis other than I want to believe one person and not another. And so I felt it better to err on the side of trying to treat all similar cases in the same fashion. If there was some way that I could do that, then I would be more than happy to. But I have backed the fine down from the original $15,000 in the hopes that the people who come forward who've only done it once or twice would be able to catch a break. But I'm still having a lineup of people who are still renting, and I'm not prone under the circumstances to treat people differently based solely on a statement. I need some factual basis to that the city has provided me as well to corroborate that. It's a sort of a truth but what is that one? Trust but verify. And I just feel that I need to treat everyone in the same way, so therefore I'm not prone to reduce the amount of the fine. I'm sorry.
Can I just say something?
Yes, you may.
Yeah, you know what I would like to say is I know for sure that there are people down there without advertising it on this Airbnb, something else, that they are doing it inside. But you know, we don't know anybody else. It's our first time. That's why that people should understand us. There are people who are there that they do it inside, that they don't put it on the Airbnb or on the social media, something, but they can do it because they know people and they are doing it for sure. But, for us, we know nobody else, we have to advertise it. Sorry for my language because I'm not, speaking a good English, but I know that you will understand me. Because we advertised it, they should tell us at least that we cannot do this and that, because they know that we don't know. That's why we advertise it. If we knew that there was something wrong, like the other people, they do it behind, that we can also do it, but we couldn't, so it's okay. For the fine, it's okay. But I know for sure that people are doing it inside.
Well,
There's nothing
I
they
have
can
to
do.
leave that to the city's ingenuity. If there are people who are doing short-term rentals, and there have been in the past where neighbors have brought folks to my attention here that may not have been on Airbnb or that one of the other websites. But again, I'm not prone to make a reduction in the fine. And that's just, I'm going to stick with treating similar situations similarly. So therefore, case number 5, RTL 032429, I find the respondent, Sayan Burhan Araya, to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes, for the property at 106 Misty Glen Lane, and to have subsequently come into compliance on February 28, 2024, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you, Your Majesty.
Thank you.
Case number 6, RTL 032430, BH Daytona LLC, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.a.2 at 431 North Grandview Avenue.
Could you state your name, please?
Heidi Myers.
And your relation, well, let me go ahead and swear you in. Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
And your relation to BH Daytona LLC?
My husband and I own it.
All right. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed February 23rd, 2024, and and they were notified the same day. The property stopped actively advertising as of February 27th, 2024. The daily posted rate was $121. The check-in, check-out time show is 3 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson?
Good morning, Ms. Myers. I previously expressed to the magistrate the city's position regarding irreparable and irreversible. Is that something you need me to present again, or
No.
are you willing to waive me reading that again, and I
Yes.
will enter that into the record?
Yeah.
Okay, well, I would ask that it be incorporated into this proceeding.
Okay. Therefore, I hereby incorporate Mr. Jackson's statements regarding irreparable and irreversible, which he provided in case number 4, RTL 032428, and incorporate them into this proceeding. Okay. Anything further, Mr. Yates?
No, sir.
Jackson?
No, sir.
Okay, Ms. Myers?
I'll pay the, it sounds like that's not, that I have to pay the $1,000, and that's fine. I won't do, we took that down right away when we found out. My husband talked to him and took it down.
I understand, and
I mean, we would like to pay less, but whatever you say.
I have no problem assessing a lower fine if there were circumstances that warrant it, or that there was direction from the city in some fashion that said, but again, I'm each month look at half dozen to a dozen cases, and the word just doesn't seem to be getting out. And as I had said in the previous matter, renting a property is in itself a violation of city code, because the city pretty much has ordinances that govern all of the rental properties. Regulation of all rental properties, short-term, long-term, et cetera. So it's sort of like a double violation in a way.
We have a
I believe they do have a BT on that property.
yeah.
They do.
Yeah,
Yes.
we do.
They can do,
Whatever
That's for
BT
long-term.
correct.
For long term.
She was saying, because you had said it was the double violation, that she does have that part.
Yeah,
Okay, well.
we have that. We just thought we could do it, but we couldn't. So,
Could I ask, and I can only suggest this, that on the one of the forms for BTLs or for rental licenses, to put in bold, short-term rentals are prohibited in Daytona Beach except in, or wherever, so that people are provided with notice as much as, I'd prefer to see you not here. I would prefer to see that there are no violations, but each month I get half dozen new ones.
It's a whole different process, and it's whole different departments that deal
Okay.
with each of those. She has a residential rental license, long-term residential rental
Okay.
license,
Well,
which includes a business tax receipt.
but it's for a long term, and that's 6
It's for
months
long
and a day.
Correct.
So that in itself doesn't absolve you from wondering why it is that your license is 6 months and a day as opposed to overnight or weekly or what have you.
it's fine. As soon as we knew, we took it down, and I understand.
I understand, and I would like to reduce fines, but I would also like to have direction in that regard so that I can apply it fairly across the board. And at these hearings, like I said, this is not a trial. I get a snapshot of what is occurring, and I'm not really in a position to distinguish between this person and that person. It becomes an impossibility for me in terms of trying to make that determination, except if there are some type of extreme circumstances. And again, ignorance of city codes is not generally an excuse.
Okay.
So, do you have anything further?
No, I just, whatever you say.
Okay, therefore, in case number 6, RTL 03-2430, I find the respondents BH Daytona LLC to have been in non-compliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes for the property at 431 North Grandview Avenue, and to have subsequently come into compliance on February 27, 2024, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
So I'd pay $1,000 somewhere.
We'll send you a invoice.
Oh.
Yeah, he'll have to sign the order first. There's nothing in there to pay yet. He will need to sign the order, and then we'll mail that out to you.
Okay, thank you.
You're welcome. You can pay it online, but we'll mail it out to you.
Case number 7, RTL 032431, Jihan Rosado, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 531 Phoenix Avenue.
I believe she's appearing via Zoom.
Yes.
Okay.
Oh, sorry, I didn't write this one down. Could you state your name, please?
Yes, my name is Ari Rosado.
Say that again.
Ari Rosado. It's A-R-Y. And last name R-O-S-A-D-O.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I swear.
And your relationship to the owner?
I'm the brother.
Brother.
And he's authorized you to handle this on his behalf?
Sorry?
Has he authorized you to handle this on his behalf?
Yes, sir.
I'm good.
Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed February 28, 2024, and he was notified the same day. The property stopped actively advertising as of March 1st, 2024. The daily posted rate was $131. The check-in time shown as 3 p.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
All right. Mr. Jackson?
Mr. Rosado?
Yes.
I previously took a position that I stated on record to the magistrate as related to irreparable and irreversible in nature, which is a finding that I asked him to make. And I don't know if you were on or able to hear that when I did that. If you were, the question is, do you need me to present that again? If you weren't on, then I will go ahead and present it again. So just let me know.
Yes, I wasn't on.
I'm sorry?
I wasn't on.
Okay. Well, I'll go ahead and present. So the city's position is that these violations are irreparable and irreversible in nature as provided in Chapter 162 and Section 162.09, parenthesis 1D. And the position of the city as relates to irreparable or reversible is that these violations are a beneficial gain to a property owner who is advertising conduct that is prohibited by our city code. It affects renting property or holding out property as vacation rental that can't be reversed and can't be repaired. The property is advertised worldwide markets, destinations that draw people from all over the world, such as our Daytona 500 races, Bike Week, Biketoberfest, and throughout the spring and summer to our world's most famous beach. The properties may also be maintained as a draw to nearby, may also be marketed as a draw to nearby destinations such as Disney World and the Space Coast. Once the properties are advertised, you can't unadvertise them. Can't push it back into the tube. Once it's out, the information can be posted, can be printed, can be saved, can be forwarded, can be retweeted, and even copied and posted on other sites. And it limits the city to the only solution for the advertisement is to require that all postings be removed. SmartSightings.com marketing website provides that as of October 2023, 4.95 billion people around the world use social media and can be reached by advertisement.
The information has long-range effects in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that the patrons enter into at their own risk. A single day of advertising can potentially book a property for a whole year. These promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotel, motel, and lawful vacation rentals that have gone through proper zoning regulations, proper inspection, proper licensing, proper insurance, and proper taxation required by law. The transient nature of rentals limit the means of the enforcement typically to identifying advertisements. By the time code enforcement arrives to properties, the transient patrons are typically gone from the property, or they claim some misleading relationship that's often contradicted by the guest comments that are advertised. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against the lawful accommodation businesses and lawful vacation rentals. The community effect is that the transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from the traditional and reliable residential norms. There is a demand from the business community to our commission, which has led to a request for a strong deterrent to those who are raking in profits, avoiding the local taxes, avoiding zoning requirements and regulatory controls. We understand that some of these sites will take taxes, but it's not covering the local taxes. We have all seen rentals going for amounts as much as several $1,000s a week and realize substantial fines is the only deterrent tools available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for a transient guest. Therefore, the city requests the finding that these violations be deemed irreparable or reversible in nature. And in addition to that, we also remind the magistrate, and we speak to this issue, that for the sake of the fine, we look to the gravity of the violation pursuant to our code, pursuant to Florida statute. The efforts are to respond to comply and the gravity of the violation. And so in that regard, if a property takes a long time to comply or continues to advertise, we generally ask for the maximum fine of $15,000. Over time, we began asking for a lesser fine for those who immediately respond. With that being said, we just ask that the magistrate make the finding that these violations are irreparable and irreversible in nature. That's all I have.
Mr. Yates, anything further?
No, sir.
Oh, okay, then, Mr. Rosado,
Yes.
it's your turn.
Well, actually, I want to acknowledge the mistake I made of an awareness, not defiance. Like, upon renting my property through Airbnb, I was not aware of the Daytona Beach specific rental laws. I assure you this oversight was not intentional. And once I was informed of the violation, I immediately took corrective action, including removing listing and refunding my guests. Like, I deeply respect the laws, and I'm committed to fully compliance moving forward. Like, I humbly request your leniency in this matter, considering my immediate effort to rectify the situation and my genuine lack of prior knowledge. I appreciate your understanding and guidance, ensuring an oversight does not happens again.
Okay. Do you have anything further?
No, sir. Thank you for considering my request.
Mr. Rosado, I don't know if you were listening to the previous matters, but I have taken into account the fact that people who respond quickly are treated differently than the people who choose to simply continue. And we've had a number of those where they just continue for a week or two or a month or what have you, or just totally ignore the code. And so that has been taken into account. I understand that nobody wants to pay any fine for anything, and I certainly understand that. But the reality is the fine has been reduced significantly from what it was initially for people such as your brother's situation. And at this point, as I have said before, a couple of things. One is it is a rental, and a rental is a business. And generally, people who go into business check out city codes and check out with the city itself, find out what's necessary. That wasn't done. It's specifically prohibited in this particular area, and therefore that wasn't checked out. And therefore, there are arguments that relate to why somebody who is setting up a business didn't go through what people in businesses typically do, and that is research whether or not their business is allowed in the community first, as opposed to setting it up and then finding out later. But due to your your brother's quick response, that's been taken into account. And instead of him looking at potentially a fine of up to $15,000, the city has asked for $1,000, and that is what they have asked for traditionally now for some years now. And therefore, I'm not going to reduce the amount.
Okay.
So therefore, in case number 7, RTL 03-2431, I find the respondent Jihan Rosado to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 531 Phoenix Avenue, and to subsequently come into compliance on March 1, 2024, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again. For any future repeat violation, respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you.
Okay, case number 8, RTL 03-2432, Opulent Home Health Care, LLC, cited for failure to correct violations of the Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.8.2 at 1249 Swanee. Is there anyone here on behalf of Opulent Home Health Care, LLC? There is no respondent present. Mr. Yates?
Case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed February 29, 2024, and they were notified the same day. The property stopped actively advertising as of February 29, 2024. The daily posted rate was $179. The check-in, check-out times show as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson? I think it's appropriate with the respondent not being here that you read your comments into the record.
Well, I would say, though, there is no respondent to object, so I am okay with incorporating my prior
I think it would be good to have a record of this proceeding in case that there is something that I'm unaware of as to why they're not here.
Understand.
They will see that the record, that everything was presented and...
Understand. So the city's position is that these properties, this violation is irreparable and irreversible in nature, and would ask that you make that finding in this case as well. The nature of the violation is that it's a beneficial gain to property owners, advertising conduct prohibited by the city code, affects rental properties, by holding out a property as a vacation rental that cannot be reversed or repaired. You can't undo that. The property advertised worldwide, marketing destinations that draw people from all over the world. The principal special events such as our Daytona 500 races, Bike Week, Biketoberfest, and throughout the spring break and summer to the world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney World and Space Coast. Once the properties are advertised, they're never truly unadvertised. Or once visitors come to these properties become a noted location for possible rental in the future. So the information is often printed, saved, forwarded, retweeted, and even copied and posted on other sites. And they limit the city to the only solution for the advertisement is to require that all postings be removed. SmartSightings.com marketing website provides that as of October 2023, that 4.95 billion people around the world use social media and can be reached by the advertisement. The information has long-range effects, luring patrons under contract to participate in unlawful stays in our city, and these patrons have a risk of poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons into at their own risk. One day of advertising can potentially book a property for a whole year. These stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspections, proper licensing, proper insurance, and proper taxation that's required by law. The transit nature of the rentals limit the means of the enforcement, typically to identifying their advertisements. By the time code enforcement arrives to properties, the transit patrons are typically gone from the property, or they claim some misleading relationship. That's often contradicted when you see the guest comments. The monetary effect of these unlawful rentals is that they're tax avoidance, especially or specifically to local tax. They have inadequate insurance coverage and unfair business competition against the lawful accommodations businesses and the lawful vacation rentals. The community effect is that the transit businesses are within unauthorized residential neighborhoods, and they affect the density, the parking, the noise, and the safety in those neighborhoods. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from traditional and reliable residential norms. There's a demand from the business community to our commission, which has led to requests for a strong deterrent to those that are raking in profits, avoiding local taxes, avoiding zoning requirements, and regulatory controls. We have all seen rentals going for amounts as much as several $1,000s a week and realize substantial fines is the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or irreversible in nature. And as we typically remind magistrate that we take a position that the maximum fine on these is $15,000, and we generally ask for that for someone who has been exceeded a certain time period of after they've been notified. Ideally, we would like them to respond immediately, and when someone responds immediately, we recommend what has become your minimum fine of $1,000. And so with that said, that's our request is for there be a finding that these are irreparable and irreversible in nature as pursuant to Chapter 162, 162.09, sub 1D.
Okay. There being no respondent present, and based on the evidence that was provided, I'm finding this respondent to be in violation, and I will read the order. In case number 8, RTL 03-2432, I find the respondent, Opulent Home Healthcare LLC, to have been in non-compliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 1249 Swanee, and to subsequently come into compliance on February 29th, 2024, and hereby order a respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Okay, before I move on, Mr. Yates, I have a question for you.
Yes, sir.
I've noticed in a lot of these pictures, they all look like they're done by almost the same photographer.
Yeah.
Do you know who?
Okay, a lot of the photos you're seeing in that case are the photos from the real estate websites that I pull down from when they sold the property, which is how I'm able to match up the insides of their homes.
Okay.
So that's why you're seeing the same local photographers over and over and over on the insides of the properties.
Because they're very nice pictures.
No, they do. They're doing a good job.
Yeah, I was just wondering.
Don't tell his secrets.
I thought maybe there was someone out there who was in this business and, they could be told, maybe you want to tell your clients when you take the pictures for these photos
I wish.
that they might as well make sure they can do it first.
No, we hand the every real estate agent person I talk to, I give them the web address for the interactive map they can use to look at everyone. So we try to get the word out there. We do.
Okay. Case number 9, RTL 022424, Kenneth Metzler Jr., cited for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.8.2, at 213 Jessamine Boulevard.
Case before you is a zoning violation. This case was field generated. The property is zoned SFR5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed January 26, 2024, and they were notified that same day. The property is still actively advertising as of today. The daily posted rate was $425, and it displayed 17 reviews. The check-in, check-out time show 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $15,000.
Okay. Mr. Jackson, before you get up, let me just call out one more time. We have an empty audit room here, but I will ask, is Kenneth Metzler here? Did Kenneth Metzler ask to be on Zoom?
No, sir.
Okay. Then there is no respondent present. Oh, and let me, before we do one other thing, was Mr. Metzler properly notified at today's hearing?
Yes, he was. Was he at the last hearing, Kevin?
He was not.
I can't remember. Okay. So,
Was that when we continued?
Yeah, for
Yes.
noticing, and then he had his proper notice.
does he have proper notice?
Yeah, I did hand delivery of those.
Okay. Well, you can say that on there.
Oh, that's why you continued it. Remember now.
Mr. Yates, if you
So
could come
the
back.
property was posted,
Was posted, okay.
and I'm sure he mailed, but he said he hand delivered.
Yeah, and then it was hand delivered for the first one. Yeah.
So
And-
the first was handled, you had actual contact with the.
Yes, and the other one was mailed.
Okay, I want to be clear on that. You actually handed it to the owner?
Yeah, and they signed it. Yes, sir.
Yes,
Oh.
which is reflected on the posting. It was hand delivered.
Okay.
And
And
I told him how important it was, and I told him in so many words that if this isn't down, I have to charge you $15,000. Please take it down. Those were the words I used.
Okay.
And the
And
last time you checked was?
This morning.
And as of this morning, it was
Active.
still active.
Yes, active both on VRBO and Airbnb, both websites.
Okay, and there's reviews,
17.
17. So-
17 on one and one on the other.
Okay.
So a total of 18.
And what is the monthly, the hour, daily rate?
$425 was the daily rate.
Oh, okay.
I will say, we did get the letter back for the notice of hearing as unclaimed.
Okay,
So there was obviously a notice left, and it was unclaimed.
okay. Then, Mr. Jackson, please proceed.
And again, this would be a request for a finding that the violation in this case is irreparable and irreversible in nature as provided in 16209 1D of Florida statute, 162.09 1D. And the city's position is that this is a beneficial gain to the property owner who is of advertising conduct that is prohibited by a city code and affects rental property by holding it out. Property as a vacation rental and it cannot be reversed or repaired. Property is advertised worldwide, marketing destinations such as the 500 races, the Beach Street, and Bike Week and Biketoberfest, and throughout the spring and summer months, the world's most famous beach. The properties may also be marketed and as a draw to destinations such as Disney World and Space Coast. Once the properties are advertised, they can't be unadvertised. You can't put it back in the tube. Once it's out, it's there. Information posted today can be printed, saved, forwarded, retweeted, and even copied and posted on other sites, limiting the city to the only solution to the advertisement is to require that all postings be removed. Smartsites.com marketing website provides that as of October 2023, 4.93 billion people around the world use social media and can advertise and can be reached by the advertisement. The information has long-range effects. It lures patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and poor welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. A single day of advertising can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, definitely to the detriment of the licensed hotels, motels, and lawful vacation rental that have gone through proper zoning regulation, proper inspections, proper licensing, proper insurance, and proper taxation that's required by law. The transit nature of the rentals limit the means of the enforcement typically to identifying the advertisements. By the time code enforcement arrives to properties, the transit patrons typically are gone from the property, or they claim some misleading relationship that's contradicted by the guest comments. The monetary effect of these unlawful rentals is a tax avoidance, inadequate insurance coverage, and unfair business competition against the lawful accommodations businesses and the lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from traditional and reliable residential norms. There is a demand from the business community to our commission, which has led to a request for a strong deterrent to those that are raking in profits and avoiding taxes, particularly the local taxes, avoiding zoning requirements and regulatory controls. We have all seen rentals going for amounts as much as several $1,000s a week, and realize substantial fines is the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests that the magistrate, that you make a finding that these violations are irreparable and irreversible in nature. We further request that you look at the gravity of the violation and the effort of the respondent to come into compliance. From the testimony of the inspector, this respondent was put on notice of the necessity and the importance of coming into compliance, and to this date has ignored the compliance and continues to move forward with this violation. The gravity violation is substantial. We request the maximum fine of $15,000, and we believe it's fully warranted. That's all I have.
Okay. Thank you. Mr. Yates, I have a question to you. You said there were 17 reviews?
Yes, sir.
That's just the people who chose to review.
Correct. You don't have to review, and there's no need for you to have. And as recent as 2 weeks ago, yeah.
Okay. And you spoke with the property owner?
Yes, I believe so.
All right. Well, under the circumstances, he certainly warrants the highest fine available. So therefore, case number 9, RTL 02-2424, I find the respondent Kenneth Metzler Jr. to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 213 Jessamine Boulevard and has yet to come into compliance, and hereby, as of this date, is still not in compliance, and hereby order that respondent shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again. And if for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you.
Okay.
Kevin.
One more matter.
This one will be easy. Do we have, there we go.
I think we can keep the crowd under control here.
Mr. Villamontes, can you hear me?
Thank you.
Can you hear me?
Yes, ma'am.
Okay.
This is, I need to read in
Okay, go ahead.
miscellaneous business. MB1, RTL 07-22-140, 516 Phoenix Avenue, property owner 516 Phoenix LLC. At this point, I believe we're here on a lien.
This was a lien review that was dismissed without prejudice, and you directed him to get with city staff.
Okay,
see if
and
they
there
could
was
come to
a
a
amount due on that was here is posted as $10,617.17.
Correct.
Okay. And
the city has come with an agreement, sir.
oh, you have an agreement.
Yes, 2,000.
Agreements are always good.
Yes.
Okay, and what is the agreement that has been reached?
To be reduced to 2,000.
Okay. And I take it that Mr. Who was here on behalf of the?
Mr. Villamontes, sir?
Yeah, I haven't sworn him in yet.
Okay. Well, why don't you swear him in? I don't know, I'm going to be asking him any questions.
Okay. Could you raise your right hand, please?
Yes.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am. I do. I do have some things to say, though, please.
Okay.
Okay, well, if you have some things to say, then it's good that you were sworn in. And that is something that the city finds acceptable? And Mr. Viamonte, you find it acceptable? So, Mr. Viamonte, you can say some things if you would like.
Yes, sir. Thank you, Your Honor. I was fined $10,000 on this for a first-time offense. It was a studio apartment that I put on VRBO. As soon as I found out that I wasn't allowed to rent it, I took it down. I've told you this before. My property is now in foreclosure, needs a roof. I told you this last meeting. You told me to get with the city to see if they would reduce it. But after hearing today's hearing, I saw that 1, 2, 3, 4 cases out of the 5 were first time, same thing as me, first time, but they were renting their properties for a lot more than what mine was advertised for. And I lost out. Not only did I get a $10,000 fine, but then to fight that fine, I had to pay an attorney $4,000 plus court costs and filing fees. So I ended up paying this attorney $4,000, who did me no justice at all, and I ended up representing myself now again with you. I represented myself when I talked to the city yesterday to get this reduced, but and I did agree to the 2,000 because they said that's the lowest that they could go. But I'm seeing today that 4 out of the 5 cases for first-time offenders was $1,000. I'm already $4,600 and some odd dollars into this. I'm hoping that I can get this reduced like everybody else's fines, and they didn't even have to pay an attorney to fight the $10,000 fine, and they didn't have to go to foreclosure and get a lien on the property, all the things that I've already done. But I'm in the same boat with them. I'm just one of the guys that was put together with another guy that was a repeat offender at the time, and we had the same attorney. So you guys heard the cases back to back, and he got fined $15,000, and then I got fined $10,000. But we were not the same case at all. I'm a first-time offender. As soon as I found out, I stopped advertising the stuff on Airbnb and VRBO, and mine was a studio close to the beach that I had advertised at $87 a night. You had one person today at $168 a night, another one at $180 a night, another one at $121 a night, and another one $179 a night. All 4 of those people were advertising for more and renting for more, and I was less and didn't rent it and got fined $10,000 on my first time offense. So I know I came to an agreement yesterday with the city because that's what they told me that they could go down to was $2,000, but I'm pleading with the court and begging you if you could please reduce it to the $1,000 that everybody else got. And even with that, I've already lost the $4,600 that I paid the attorney and the court costs. Please, sir.
Okay.
Yeah, Mr. Magistrate, Anthony Jackson, attorney for the city. Mr. Biamonte, so I think as I remember the way the hearings went, I guess our first problem was that, well, I can't answer for what your attorney did or didn't do, but you did get an attorney, you did appeal it, it was lost in appeal. And so that's kind of the starting point and what makes you different from the others. I know, I understand the points that you're making as far as your expenditures and things like that. We didn't really come in anticipating having to argue this case, but if we were to go ahead and argue, that would be our position, that this has already pretty much been heard by which is what the magistrate initially had said. It's just been heard by a circuit court on appeal, so it was pretty much done with, except that out of recognizing the hardships that you expressed, I think I volunteered that we should get with you and see what we can do to
Yes, you did.
try and improve your circumstance. So with that being said, I believe that 2,000 is reasonable. We did a lot of things to try and make sure that we got together. I think my paralegal was, as much as she could be, helpful in terms of giving you guidance on what you would need and how we can get you some help and get you in a better situation than you were in on that date. And so I understand the request, and it's easy to get that request when you sit and see things throughout the day without all of the circumstances and all of the facts. And your facts are difficult facts, I understand that, but there are certain things that we believe would support us not being as lenient as we ultimately has chosen to become.
Mr. Jackson and Your Honor, I was grouped in again with another guy who was a multiple offender, and even in the when we went to court, his case was heard at the same time as mine. They were both heard together, And my case is exactly the same as 4 out of the 5 cases that you already had today, because I advertised, you guys told me I wasn't allowed to advertise, I took it down. You fined me $10,000 because at that time, and it's a first time offense, and I've never had a code violation, ever had a code violation. And I do have a business tax license for that property, and I pay my business taxes, and I do have a residential rental license for that property, which I pay taxes on as well. I'm now at the point where it's in foreclosure. I need to get a roof. These are the reasons you guys heard me for reduction. You know, I'm not an investor. I bought this property with my savings, and now I'm trying to sell the property before it goes to foreclosure. I don't see why I should be treated worse than 4 out of 5 cases I just heard. I got $1,000. I've already spent more time, and like you said, Mr. Jackson, I'm the one who contacted your paralegal over and over again to say, hey, when are we going to get together? What do I have to do? What do I have to send? I sent in all the hardships. I sent in the estimates. I sent in my ID. I have my bank account information. I've done all that work to get this reduced, and it was a first-time offender, just like everybody else, except for mine. Mine was less than theirs, and I ended up paying more. I fell through the cracks as far as getting a $10,000 fine, being grouped in with somebody else because we're the same attorney, and now I'm paying for it. Even if I had this fine at 0, I still lost almost $5,000. And I do get inspected every year by Daytona Beach and by the state of Florida on this building. And I have my business tax up to date, and everything is up to date on that property. Never had a code violation. I please request and please ask again to at least reduce me to what everybody else has, which is $1,000.
Mr. Jackson?
No, our position is unchanged.
No, I have a question for you.
Yes, sir.
I see there's a verified complaint that was filed. Did this go to circuit court?
Yes, it did.
And what was the result?
This was, it was an appeal, and the appeal was denied.
Okay. So technically, the $10,000 was upheld by the court.
Well, yeah, that's what I meant, yeah. They affirmed
And
the
so
order of the
you have
magistrate.
agreed to work with Mr. Viamontes.
Right.
And you've reduced it. Now, I said today, maybe Mr. Viamontes didn't say it, this is not 2022. This is 2024. And at that time, the fine which I imposed was typical of the fines that were imposed upon all the people who appeared before me in 2022.
Right.
And that was upheld by the circuit court. Okay? You subsequently, you don't have to. I mean, the circuit court, or the court is the arbiter of these matters. The court upheld $10,000. You've worked with Mr. Viamontes, and you had agreed on a amount of $2,000. And quite frankly, at the time, $10,000 was considered to be acceptable. Now, I'm not prone to reduce it. So I will reduce it to $2,000, but that's as low as I'll go. Your case is not being heard today. Your case was heard in 2022. And this is trying to take advantage of the calendar and changes in the way that things may be done, but I'm going to apply the same standards then as would be applied in 2022. And if 10,000 was okay in 2022, reducing it to 2,000 is certainly an $8,000 reduction for the respondent in this matter.
And just, I know this isn't necessary based on what you just said, Mr. Magistrate, but just based on the minutes record from July 26th of 2022, Ms. Elaine Enrica was an attorney who appeared on Zoom on the behalf of this property. And the inspector reported that the violation was noticed on June 8th of 2022, and it was not in compliance until July 19th of 2022. So it was more than a month before this property came into compliance,
Okay.
not immediately the next day. I'm sorry about the recollection of Mr. Diamante.
And I'm also looking here in this property had reviews. And as I had asked Mr. Yates earlier today, what do reviews mean? Well, that means some people review it, but there may be others. So even from
Not that
today,
it matters, but I had friends stay there so that it would give me reviews, so I would have good reviews on.
I'm not going to go there,
Understand.
whether friends or what have you.
I mean, the alternative is the city to withdraw our recommendation, and we rely on the outcome of the circuit court. I'm not, that's not a threat, but it is the alternative.
I mean, there's only so many bites of the apple you can get. And in the statutory process, the city levies a fine. And then if you feel that fine is inappropriate, you appeal it to circuit court. And if the court feels it's appropriate, then they uphold what was done. In this case, the fine was upheld. So you actually have gotten around the circuit court. City doesn't have to negotiate with you.
I understand. Okay.
So
Thank you for your time.
so then is this a lien reduction?
We called it you had made the ruling previously without prejudice, so it would really be a lien reduction. We called it a miscellaneous business because we understood, even though it was announced that way, the intent was that we would be coming back more like a continuation, but you did have an order announced. So in that regard, it would be a lien review or a lien reduction.
Well, I would expect that Mr. Viamontes in the proceeding that he is currently involved in will need some type of paper that recognizes that the $10,000 outstanding lien has been reduced to $2,000.
Yes, and that'll be,
I'm going to use my lane review paperwork.
so we
have
will look at it as a lien review from that perspective, as a continuation of the prior lien review, but as a lien review so that we can have the form that would indicate
Correct.
the reconsideration. Well, I'm calling
It became a lien once the circuit court upheld.
Yes.
I mean, became a lien once it was recorded against the property and it's upheld by the circuit, so it's a lien.
Yes.
So I'm going to do it as a lien reduction. Do you
Yes.
have a problem with that?
No, not at all.
Okay. Therefore, in case RTL, or in matter RTL 07-22-140, property at 516 Phoenix Avenue, owner 516 Phoenix LLC. I order the lien in that case to be reduced to the amount of $2,000. Will this be subject to being paid within 30 days? Subject to being paid within 30 days, or the fine will revert back to the original amount, which was $10,000.
Yesterday, Mr. Sykes, Your Honor, yesterday Mr. Sykes says he was going to give me 90 days. That's what he said yesterday in our hearing. Ms. Barnes was there as well. I told him I don't know if I have 90 days because of the foreclosure proceedings, but he did say he was offering me 90 days to pay it.
He said,
Denzel said normally it's 30 days, but he would work with him.
Okay, we're okay with that. I mean, in terms of that time period, you're really the one that's under the gun, right? If
Yes, sir.
you
Yes,
take
sir.
90 days and they take action.
Yes, sir.
You
Yes,
know,
sir.
in 30 days. So
I'm
you
borrowing the
should be
money,
wanting
so
to
that's
do-
why I don't want to be on the hook for the 30
Okay.
days, but it may be in 60 days. But you're right, I'm the one who's under the gun.
Yeah, I'm fine with the 90 days.
I wasn't privy to those discussions, and so I'm fine with 90 days if the city's fine with 90 days.
Yeah.
Thank you.
So therefore, I will to be reduced to the amount of $2,000, subject to being paid within 90 days, or the fine will revert back to the original amount. And I'm going to add a little caveat here. If you run into a problem where you need additional time, please contact Mr. Jackson, and I don't have problem providing you with additional time. So if 90 days, if you find out that for whatever in your proceeding, you may need 120 days or something, I can provide you with additional time.
Yes, sir.
And just modify this order,
I appreciate that.
okay? And just keep the city in the loop as to anything that you may need or discuss with them
Yeah, I believe
to
Ms.
this
Barnes
matter.
told me yesterday that she will get me the paperwork needed so that I can make the payment and satisfy the lien.
Okay,
Very good.
thank you.
Thank you for your time.
All right. Is there anything for
No.
it being 12:37? I hereby call that the the March 26, 2024 rental program special magistrate proceeding is hereby adjourned.